Thanks to all you for coming out. What a fantastic turnout. It's amazing. Why could you possibly be so interested in privacy? It is a great turnout, and I think it does reflect the growing consciousness of the importance of privacy and the risk that it represents to you and to your enterprises. I thought that today I would give you a kind of very brief Privacy 101 in general terms, and then talk about some of the recent developments that we've seen in the field of employment and some of the ways in which privacy law touches employment law. And many of you will probably be familiar with the basic concepts, so I apologize to those, but I've always thought getting a sort of common understanding of the baseline points is quite important. So if you are familiar with these concepts, please bear with us. This case that you see on the board there was really a watershed moment in 2014, I think, when NZCU Baywide had an award of $168,000 made against it for a kind of sustained and malicious series of privacy breaches against a former employee. Some interesting elements of the case that we can discuss later. But let me just give us some common understandings of what we're talking about. If we're going to talk about the Privacy Act, there's two principal concepts we need to understand. First is personal information. The Privacy Act regulates the collection, use, and dissemination of personal information. And that is a term that is defined very broadly. It's defined as information about an identifiable individual. So just pause for a moment and think about that. There's no qualitative element in that definition. It doesn't say sensitive information or private information. Now, the word privacy really occurs in the title of the Privacy Act, and not, effectively, the word private doesn't occur particularly in the Act at all. It's about personal information and imposes a set of principles, which I'll take you through in a moment. So personal information is information about an identifiable individual. John Edwards was a district inspector under the Intellectual Disability Compulsory Care Act. John Edwards is in Auckland today wearing a blue suit. This is personal information about me. It's not sensitive. I don't care about it. Dissemination of that information would not cause me any harm. But there it is. That's the breadth of it. The law treats it equally, essentially, as information about my HIV status, about my sexual orientation, about other things which we might consider far more inherently or intrinsically intimate or personal. Next concept is the idea of agency. So the Privacy Act regulates personal information that is collected or held by agencies. And that is a term for the kind of entity that we're dealing with. That term also is incredibly broad. It says it's so wide, it's defined with reference to exclusions. So it says an agency is a person or body of persons, corporate or unincorporated, but does not include the Governor-General. So he's out. Gee, oops, sorry, update my vice-regal references, pronouns. The Governor-General is not. Courts in relation to their judicial functions are not an agency. The news media in relation to their news gathering and dissemination functions are not an agency. Everybody else is. Anybody here is not from an agency. The Employers and Manufacturers Association is an agency. You all are from agencies. You all belong to many agencies. Anyone here belong to a golf club? That's an agency. Anyone belong to a church? That's an agency. Anyone take their kids to a scout group? Or you get the idea. Sports clubs, banks, government departments, law firms, they're all agencies, so they've all got to deal with this. So when you put these two concepts together, you see the incredible breadth of the work that we do and the obligations that this Privacy Act of ours creates. I sometimes tell new staff that are joining us that our kind of jurisdiction is bounded only by the limits of human activity. So when you have a law like that, the lawmakers have first to make a decision about how they go about regulating the conduct of so many actors in the economy in relation to such an enormous variety of types of personal information. And the decision that many countries have alighted on is to to avoid a very prescriptive and certain approach to legislating. We see prescriptive legislation in the Tax Acts, don't we? You've got to know what the tax rate is for any particular situation. And if you're a single person who is a seasonal worker with 2 dependent children, you need to be able to flick open the Tax Act somewhere and find exactly what the law that applies to you is in relation to your tax obligations. The same cannot be said for the Privacy Act. Because of the infinite variety of combinations of agencies and items of information, the legislators chose an approach of very general application, that there are general principles. And I want to talk you through those very briefly as part of this Privacy 101. I'll come to those in a moment, because there's another element that I haven't as a slide term. But the other element that's important in New Zealand's context is harm. And this is one that's often overlooked. And many of your lawyers will overlook it. Your liability for a breach of one of these very general principles is determined not by whether the lawyers say you've complied or not complied with that principle, but whether your action has actually caused some harm. There's a couple of exceptions to that, but I'll come to those as we come through. But it's really important. The law is not certain in some places. You've got to make judgments. And I know it would be much easier for all of you if I were to just stand here and say, here's the rules about referees. Here's the rules about drug testing. Unfortunately, you have to make those decisions. But if we flip that over, that gives you enormous latitude to generate your own policies in a way that best suits the kind of business that you have. All right, so let us begin a quick tour of the information privacy principles. There are 12 of them, and they live in Section 6 of the Privacy Act. The first 4 deal with the collection of personal information. The information privacy principles kind of follow a life cycle of information. And when I briefly introduce them to you, I'll come back and we'll show how those can be applied in relation to the life cycle of an employment relationship. So, you know, when you are recruiting someone, you're collecting a lot of information about them. When they're working with you, you've got certain obligations and so on. So the first principle is what the Europeans call the data minimization principle. In New Zealand, it says an agency shall not collect personal information unless that information is necessary for a lawful purpose. So if you don't need it, don't collect it. Simple stuff. The second principle says you should try and collect personal information directly from the individual concerned. All right? That's the general principle. How many people breached that principle today? Everybody. I'm sure you did. You know, when I came into the office and said, "Where's Sophie?" This is Sophie, by the way, who works for me. Then I'm asking somebody else for information about a third party. So I'm not collecting personal information directly from the individual concerned. It doesn't matter. So we don't need to get too uptight about the rigidity of these principles. These are saying, here is best practice. Where you can, do it this way. For this principle, as with several of the others, there are exceptions. So it's not a breach of the principle, for example, where collecting the information, as in that instance when I inquired about Sophie, would not prejudice the interests of the individual concerned. It's not a breach to collect information from a third party when complying would prejudice the purpose of collection. Or, which is most common, the most common one that you would use in the referee context, for example, it's not a breach of principle to collect information other than from the source, other from the individual concerned, where you're doing so with the authority of the individual. So when someone applies for a job with you, you say, who are your referees and can I contact them? And they have then authorised you to collect those. We'll talk about the consequences of that in a moment. Now, I told you a moment ago that you could pretty much write your own Privacy Act. Well, if I didn't, that's what I meant to say. I said that the principles gave considerable latitude. You know, the trade-off for the very general approach of the information privacy principles is that you have scope to form your own policies and principles. And for most of the organisations in this room, in fact, almost all of them, I looked at a list, it doesn't really matter what you decide your policy is, as long as you communicate it clearly to people. So the obligation, whether we're talking about your customers or clients or your employees, is that before you collect personal information from them, you tell them why you're doing that and what you're going to use it for. So if you are a recruitment agency and you are an assertive agency that goes out seeking opportunities for the people on your books, then you make sure you tell people that that's what you do. Because if they don't like that, they can say, actually, I'm going to go to a different kind of agency, one that checks with me first before they put my CV in front of another firm. It's very empowering and important, this principle, for you. And it allows you to avoid liability in a number of circumstances. If I asked you, is it okay for you to record your employees' phone calls? What would you say? Hands up who would say yes. Are you allowed to record your employees' phone calls? Who says no? There are a few no's there. Well, good on you. But the answer that will come to in a little while is, yes, it's absolutely okay. But you've got to tell them that that's what's going to happen. And how many times a day do we make a phone call to an organisation and hear a recorded message first saying that this is going to be recorded for quality assurance or training or whatever else purposes. And then we understand that and we can choose to terminate the call and go, if we can find a human in that organisation somewhere, have that conversation or write to them or interact in some other way. It's the same with employees. I'll give you some tips a little bit later about how you can comply with that in a really simple way. The fourth principle, the last of the collection principles, is that you should not collect personal information in ways that are illegal, unfair, or unreasonably intrusive. And I'm currently engaged in an inquiry into a quite public incident of the collection of personal information where this principle is engaged, and I'm interested in asking a few questions. You may have heard about an operation in which police set up a breath alcohol checkpoint not very far from a place where a community meeting about euthanasia was being held, and stopped everyone who'd been at the meeting, or so the media reports tell us, and collected information about the name and address of people who had attended, and subsequently went along and visited. So I'm asking the police, I'm talking to the police about whether those actions were consistent with the obligations here about collecting information in a fair or not unreasonably intrusive way. So those four first principles are about collection. Once you've got the personal information, you owe certain responsibilities to your employees, to your customers, to your clients, to others, to take reasonable steps to ensure the information is kept secure against loss, destruction, or misuse or improper access. And every day in the media we see examples of a failure in this, don't we? We hear of the massive breaches such as Yahoo, which recently admitted that 500 million email accounts had been compromised on their servers. We saw just last month a very targeted so-called spear phishing attack on an organisation, the New Zealand Nurses Association, where a criminal, essentially, had spoofed the chief executive's email address and sent an email message to the person in charge of membership at the nurses organisation and said, please let me have a copy of the email addresses of all our members. And that person saw her boss's email address in her inbox, saw the request, so sent it out, and only realised later that that had been a fraudulent email and that she'd inadvertently been tricked into disclosing 47,000 email accounts to an unknown person. So the obligation is to keep information safe, and I'm going to talk to you about some of the most common areas in employment where we see that coming into question. Number 6 is about the individual's right of access to information. This is a very important principle. I know I'm saying they're all important, but Principle 6 is a legal right that people in New Zealand have had in relation to the government since 1982, and in relation to the private sector since 1993. People are entitled to see their own file. And if this is one exception to the rule that I said before, anyone who's going to bring a complaint has to show that there's been a breach of one of these principles and that they have suffered harm. Well, this is an exception to that. If you have been asked for a copy of their personal information and you just ignore that or throw it in the bin or put some stuff in another file because it's inconvenient or conceal stuff or don't properly discharge your obligations, you can find an award of damages made against you whether or not that person suffered any harm. So that should make us all sit up and want to check that we've got adequate systems and processes in place. There are a number of reasons, of course, that people can, that you can withhold information from people. And the one that's possibly of greatest interest to you today is your ability to protect confidential referee information. So don't you worry about that. If you ring someone up who's agreed to be a referee and they say, well, he's a bit sleepy on the job, don't ask him to do anything before 11 o'clock in the morning, you can withhold that information from the individual when they later ask for it. The next principle, I'm not keeping up with my slides, I'm sorry. Principle 8 says, it's the most qualified principle you'd ever see on the statute book. It says an agency that holds personal information shall not use that information without taking such steps, if any, as are in the circumstances having regard to the purpose for which the information is to be used, complete, relevant, up-to-date, and not misleading. So it's, you come through layers and layers of qualification, but ultimately the rule is you've got to check that the information is accurate before you use it. Now, a lot of people talk to me about social media, and as employers, are we allowed to Google someone? And if I were to say, no, that's improper, that'd be like King Canute trying to keep the tide back. We have this wonderful technology with these vast resources of information. Of course you're going to use them. I actually don't think there's anything wrong with making those inquiries. The information is publicly available, so in law there's plenty of defences. But I do think that there is an obligation on you to treat some of that information with a grain of salt. And if you see something that might be prejudicial in your Googling, then have a really good think about how reliable it is, and have a really good think about what a reasonable employer or recruiter might do on the basis of that information. If you've come across something that's 8 years old that shows someone doing something that looks pretty silly, you might say, well, okay, in 8 years, if 8 years have passed, is it relevant for me to take that into account now? Maybe it isn't. In Europe, a lot of my colleagues are looking at what has become known as the right to be forgotten, which in a sense is the right to have historic information suppressed. I've been a little bit more circumspect about that. I'm kind of interested in having a conversation in public as social media becomes more pervasive in a right to be forgiven. So just because you see something that somebody's done online, maybe think about your own youth and how that, how your behaviour's changed over 7 or 8 years in that space, and whether you would have been prepared to have your entire university or high school history revisited when you applied for a job in your 20s or 30s. So I do think that we owe people a duty to check accuracy. I'll hang on the book because I know that it's one that's often asked of employers. And I can't think of a better example to illustrate the folly of false confidence in what you find online. Everyone's a researcher now. We can type into Google and we think we're great, get these great insights into people. There was an insurance company in Canada who cancelled somebody's disability benefit on the basis that she was receiving an income-related allowance because of her disability, which was a depressive illness. And they saw on her Facebook page a photograph of her at a party looking happy. Now that's just nuts, isn't it? I mean, if somebody walks up to you and said, John Edwards told a fib once, you don't suddenly fire me on the basis of this unsupported evidence, but somehow people are happy to take what they see online in their amateur research as gospel. And there's always a context. you know, that appalling post that you've seen. Maybe somebody left their device unattended for a while and somebody else jumped on it and posted something for the very purpose of getting that horrifying effect. So just ask yourself what you would have someone do if they discovered something prejudicial in your timeline, and whether you should be given an opportunity to comment on it. Anyway, that's accuracy. Principle 9 says once you've got personal information, it's kind of the flip side of Principle 1. Principle 1 says don't collect more than you need. Principle 9 says don't keep it for longer than you need. And Principle 10, use information gathered for one purpose, only for that purpose. And 11, if I'd done a straw poll before and said, what's the Privacy Act all about, you'd have told me you'd gone straight to this one, don't tell anyone anything. But again, Privacy Principle 11 says an agency that holds personal information shall not disclose that to any other agency or person unless they believe on reasonable grounds, and a whole range of exceptions. One of which is, of course, that the disclosure was one of the purposes for which the information was obtained, or directly related to the purposes, or was authorized by the individual. So again, this theme of purpose is really important. So when I say the Privacy Act says don't disclose personal information, the limitation on that is in relation to the purpose that you have. So cast your mind back. Can you remember back about 12 minutes ago, I said about Privacy Principle 3, you get to write your own Privacy Act. If you've got your own policy and you say to people, customers or prospective employees or whoever, golf club members, here is what we're going to do with your personal information, here is who is going to receive it, and you treat the information consistently with that, you can't be in breach of Principle 11 because you are doing what you said. And the person who signed up to your golf club or your retirement home had that information and was able to make a decision about whether, given that, they would rather sign up with a different golf club or a different retirement home. So it's really powerful stuff, and it's important. Principle 12, I know I said before I shouldn't have favourites. I shouldn't have least favourites either, but I don't care much for Principle 12, so I won't bore you with it. It's about the assignment and use of unique identifiers. And I guess if I were to illustrate that, I don't know why I'm picking on rest homes. Did I see a bunch of, are there rest home people here? No, I use one. Okay. So if you're going to, Principle 12, for example, says if you need some system of identifying your residents apart from their name, you don't use their IRD number. You might be able to use their National Health Index number in some circumstances. So there we go. Let's move now to some kind of thematic discussion. Hiring people. What information are you entitled to collect? How much should you ask for, and where should you get it? We have case notes to help you with this. I should say that we are in the process of developing an online training module aimed specifically at employers. So this will be available for you within a few months. And we will be in touch with the EMA to disseminate that. And it will be free, and it will talk about all these things in a lot more detail. So we have many employment-based cases. One of them, a woman applied for a retail assistant job and objected to the fact that she had to consent to a credit check. And we agreed with her. We thought that you couldn't have a uniform policy that everybody applying for a job has to undergo a credit check. Credit worthiness is not relevant to every position on the books. So I guess the lesson is, think about what is the information that you need that is appropriate for the position you're recruiting for. We had another case which we had to look at under Principle 4. You'll remember that one. Looks of recognition. Don't collect information by means that are unlawful or unfair or intrude to an unreasonable extent upon the interests of the individual. Drug testing has really taken off in the last couple of decades as test kits have become more readily available and cheaper, and workplace safety concerns have increased. So there's kind of a sweet spot, if you like. Somebody complained to us that they'd been subjected to a urine test. In the particular case, we accepted that it was it was legitimate to drug test that person as I think it was a pre-employment test, because it was a safety critical position. He then changed and said that the complainant, he felt humiliated by the process. Now, as many of you will know, it's possible to adulterate urine samples. So you've got to reach a balance between respecting the dignity of the person being tested, because the only, let's not be cute about it, the only way you can be sure that you're getting unadulterated urine is by observing genital to bottle transmission. Nobody wants to do that, not the tester or anybody else, let alone the subject. And anyone who does want to do that, you probably don't want them on staff. The balance that this outfit reached was that they would have somebody giving the sample in a closed cubicle, but there would be a nurse outside listening for the audible evidence of the sample being given. I'm trying to be as delicate as the subject permits. And the complainant found that an undignified and humiliating experience because there was not a gender-appropriate listener available. And it was an interesting case because, these matters, toileting is a private matter, and it is something that we all have an expectation of privacy, sometimes less observed than we would like, if you have to use public conveniences. But in this particular case, we thought that the person had not, the agency had not breached the principle. They'd taken reasonable steps to ensure that the collection of information was undertaken in a means that was proportionate to the need and maintained their dignity. And that the gender of the listener, while subjectively was a matter of concern to the person, actually was neither here nor there. If you accepted the legitimacy of the need to have some kind of evidence, having the person behind the door is a good balance. It didn't really make much difference of the gender of the person. So we're not just pushovers. We put these things to the test. Some agencies do adhere to that slide that I put up before this one. Get all the information you can. We'll think of a use for it later. But if that's your attitude, you've got to be ready for a bit of pushback, and sometimes that can even hit the headlines. I don't know if you saw this. This is actually outside our office in Auckland. So Manpower reached the media just last month because I'm not quite sure what prompted the protest, but there were objections about the forms on which they collected information about people they were recruiting for. And one of the items said, where necessary, I think we will, you authorise us to collect information about your gender, marital status, sexual orientation, and a whole bunch of other things that you as a bunch of employment specialists will recognise you have to be very careful about, not least because there is an offence under the Human Rights Act of circulating a form which indicates an intent to collect information that could be used to base a discrimination based on one of the prohibited grounds. So that's a very convoluted way of saying it, but you don't ask people about their sexual orientation. You don't need it. So my act says if you don't need it, don't ask for it. You don't need it, you shouldn't ask for it. But if you do collect that, then you open yourself to the accusation that you have discriminated based on that information. And these people experienced a quite considerable PR downside for that kind of practice. One of the big risks we see in the security space, once you've got someone in, so I've dealt with a little bit of recruitment. We can come back to it if you like. We can talk a bit more about referees or whatever you like, and have time for questions. But once people are on board, we can't just sort of go, okay, we did our due diligence at the beginning, that's it, we're finished, they're in. Employees continue to present risk to the organisation, and we have to cultivate, if we can, a culture that demonstrates the commitment of the organisation to the preservation of privacy of customers and important stakeholders, employers and others. One of the big issues that we have is employee browsing, as we call it. People who have access to information as part of their job who abuse that access. And we see many cases of it in our job, but we see it in the media as well. Look, here's one. Wellington Hospital paid out former staff after colleagues breached her privacy. So in this case, a hospital employee snooped on a colleague. Now, a lot of hospitals and other organisations say to me, we've got mechanisms in place to ensure that celebrities and so on, their privacy is protected, so that when those people, we have a kind of A list. And I know a lot of organisations who do this, that we'll have special controls, or we'll go in after an audit and check those A-listers. You know, I don't think that that approach to monitoring employee access to databases is good enough at all. All that does is catches the big note individuals. It does nothing about the biggest area of risk, which is somebody checking up on their daughter's new boyfriend, or their next door neighbour. That kind of stuff that would not show up on a celebrity, but is potentially very undermining of the trust stakeholders have in your organisation. So my recommendation for dealing with this issue of employee browsing is to have a program of periodic random audit. So if somebody has access to more information than is strictly necessary to do their job, and very often this is the way information systems are designed, pick a sample of 10 or a dozen every month or every week, whatever kind of organisation you've got. Go to the person and say, hey, I see you were having a look at this record, can you say why? And in almost all cases, they will either say, oh, don't know, sorry, can't remember, I did 1,000 that day, or, oh yes, here is why. The thing, it doesn't really matter what their answer is. The thing is, they are being taken to task. They are being asked to justify. So next time they are looking at, just scrolling through data, they'll remember that they might have to justify clicking on any item to get further information. I mentioned recording information, and again, this is mostly a question for your own policy. It's open to you to have policies about access to the internet through your own employer's system and the consequences of that. If you've got internet traffic flowing through your own servers, then it's legitimate for you to use that to audit that IT policies and procedures are being adhered to. But again, it is very important that you clearly communicate that to staff as you go through. We've launched a thing called Ask Us, and we've got a number of responses to very commonly asked questions on our website. And with the proliferation of technology, everyone can be a movie director with their iPhone now and set you up. We find a real hunger for this kind of information. So it just depends what your process is. But if there's any doubt about the lawfulness, this case should have put it to bed. In this case, a doctor was working as a locum in a couple of surgeries, and she was told the conditions on which she was going to be employed, and she was told that phone calls would be monitored for all the usual purposes. In the process of monitoring the phone calls, the employer found that she was doing other work that was inconsistent with her contractual obligations at these surgeries, and her employment was terminated. She took a case to the tribunal and said, they shouldn't have recorded me, I didn't know about it, and it was a breach of my privacy, and the tribunal preferred the evidence that the policy of the surgeries had been absolutely clear and had been communicated to her. Access is very important, as I mentioned before. Very often, when there's a dispute arising between an employer and an employee, the first thing that the employee will do is make an access request. Give me a copy of my file, or I've been treated unfairly, let me see the interview notes, let me see the investigation, all of that. It is important to take that seriously, and this is one area where there's some quite prescriptive rules about your obligations. When you receive one of these access requests, the first thing to do is to diary the response times. You've got to get onto it. And we've seen the Human Rights Review Tribunal issue awards of damages for cases where people got the information, but there was an unjustified delay. So please ensure that your employers, that your bosses, make sure you're adequately resourced to comply with information privacy requests. And maybe even think about this more proactively. Maybe you should have a day every month where employees whose surnames begin with B in February can come and have access to their files and move on to the C's and I don't know, whatever you want to do. But actually have a culture of openness. Have a look at your file, check that everything's relevant and up to date, help us to improve the quality of our information. If you can reduce the demand for people, exercising the right under Principle 6, then you actually reduce the burden on the organisation. All right, I'm just going to do a little sales pitch about some of the resources that we've got, and then I'll pause for some questions. We have partnered with LearningWorks, tertiary education provider in Waikato, to develop training materials. Has anybody been through our Privacy 101 course? You have. How did you find it? Excellent. Thank you, ma'am. Well, we've never met before, have we? So we have developed these courses. When I came into the job, I've been close to the office for many years, and I knew that here was a source, the single best source for advice about privacy. A bunch of very smart lawyers who do little else but look at this stuff. And for 20 years, they've been doing training. And it occurred to me that nobody calls to question their qualifications to do privacy stuff, but none of them either had been trained in education. So we went to tertiary education institution and said, can you help us present our materials in a way that is consistent with best practice in an educational, pedagogical way? And so they've done that. So you've got Privacy 101, Health Privacy 101, something on credit reporting, and our next module to roll out will be on employment. And I don't know if you found this, but some of the feedback that we had was that these courses are actually a pretty deep dive and quite technical. So they are kind of a quite sort of tertiary level. We've taken that on board, and my instructions for the employment module is to really chunk it down so that you can do bits in 15 minutes. It takes 2 or 3 hours, I think. How long did it take you to do the? Yeah, it's a little bit of a commitment. But one of the great things about it is that when I come to your organisation and say, so you've had this breach, what have you done to ensure that it doesn't happen again? And if you say, oh, we've done your privacy course, I'll go, excellent, we're out of here. I might not actually, but it'll certainly be taken into account in your favour. We've also launched an online knowledge base, which will grow and evolve over time. We get asked 8,000 questions a year through our inquiries line, and we've decided that it would make sense to capitalise on what people are asking and record the answers in a way that other people can access them. Seems to make sense when you say it like that. So you can go onto our website, which is privacy.org.nz, and you'll see an Ask Us button. You enter your question. If you don't see an answer to your question, or it doesn't take you to a useful link, just bear with us, please, because what you've done there is to really help us develop it. Every week, my staff go through and collect up all the questions that didn't lead to an answer, and then we write content for them, or we tweak the back end so that if you came back and asked the question again, you would go to a useful answer. So by using it, you're really helping us develop it. And if you ask us a question tomorrow and you don't get an answer, I would hope that in 2 weeks when you come back and write a question, you will go to something helpful. So for example, I don't know if any of you are using drones in your workplace, but if you want to know about the privacy implications of drones or filming in the workplace, we get asked a lot of questions about that, and so you'll be directed to it. I told you before that you could write your own Privacy Act, right? This is really important. Don't go out of here and say this blimmin' Privacy Act, it makes all these rules, it means it's impossible for us to do our business. It's not. There's very little in the Privacy Act which imposes things that are inconsistent with your business. It just asks you to be transparent about what you're doing. And if you haven't got a privacy statement of the sort that's required by Privacy Principle 3, hop online. In 5 minutes, you'll have one that is legally compliant and allows you to do all those things that you want to do. It's not going to produce a kind of 13-page Google privacy policy or Apple privacy policy, but for most businesses that sell widgets or have a reasonably clear product line or service, you should be able to develop something with this that then allows you to put it on your website or in your brochure, or to tuck it in with the application form for a job, or however it is that you communicate with people. And for anything that we haven't covered already, you can check us out online, privacy.org.nz, or on Twitter, or many other places that we are online. I haven't talked to you about law reform, but the government has promised us for some years that we would have a new Privacy Act and new powers for the Privacy Commissioner, and we're looking forward to hopefully seeing a bill to do some of those things next year. One of the things that will be in it is an obligation for mandatory data breach notification. What that means is that if something goes wrong and a box of files gets accidentally sent to the tip and blows around in the wind, or a thumb drive, an unencrypted thumb drive gets left on a bus with a whole lot of customer data on it, or somebody hacks into your system, that there will be an obligation on you to assess that and to determine whether it is a serious, a material breach, in which case you'll be obliged to notify my office, or a serious breach, which could cause someone harm, in which case you will be obliged to notify also the individuals involved. And so this is there to address the issue that we've seen with Yahoo. So a couple of months ago, Yahoo came out and said 500,000 of our accounts have been compromised. Happened in 2014. We've only just found out about it. There was quite a few folks around who at that time went, yeah, right. And it emerged just a couple of weeks ago that Yahoo did know about that at the time of the breach. And that meant that there's this personal information about Yahoo account holders that's been in circulation on the dark web, accounts that have been compromised for 2 years, with the individuals not being able to do anything about it. And that's no good, and that's what mandatory reporting is intended to address. I think I've